The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Welcome to another special edition of the Short Circuit podcast. I'm your host, Anya Bidwal, and today on the show, we will again be talking about qualified immunity. This is our 137th episode, by the way. The first time we talked about the doctrine was on episode 1 in 2015 with Clark Neely, who is now at Cato, working on defeating qualified immunity. We also talked about the doctrine just a month ago. But a lot has changed since our discussion in May. George Floyd was killed by a Minnesota police officer, bringing the issue to the forefront of the public debate. Bob McNamara, IJ's senior attorney, and Scott Michelman, the legal director of ACLU's DC chapter, are here to talk about it. Scott and Bob both have qualified immunity petitions pending before the United States Supreme Court. Scott is representing Alexander Baxter, who was bitten by a police dog that was unleashed on him while he was surrendering by sitting with his hands in the air. According to the Sixth Circuit, the officers who unleashed the dog were protected by qualified immunity because the previous precedent only talked about the illegality of unleashing the dog on a person who is surrendering by laying down, which is apparently very different from surrendering by sitting up. Bob is representing Shanice West, who gave police officers permission to go into her house to search for her ex-boyfriend. Instead of going into the house, the officers stood on the sidewalk and bombarded the house with tear gas grenades in the hopes of getting the ex-boyfriend to come out. The Ninth Circuit allowed qualified immunity for the officers, not because the officers did not exceed the scope of her consent when they bombed her house, but because no other court had previously held that government officials cannot blow up someone's house simply because they have been given consent to go inside it. But let's begin with the basics. Scott, first of all, welcome.
Thank you. Nice to be back.
And how about talk about the Ku Klux Klan Act a little bit, which is now known as Section 1983. Why was it passed? What does it say? And why is it relevant to the discussion of qualified immunity, at least when it comes to state police officers?
Sure. So the Ku Klux Klan Act of 1871 was one of several pieces of Reconstruction-era legislation that the Congress passed in the wake of the Civil War in response to terrible conditions, mostly in the South. The unreconstructed South, or the being reconstructed South, was very hostile to the rights of newly freed individuals who had recently been enslaved. And so there was white supremacist violence rampant throughout the South, including by the newly formed Ku Klux Klan. Some of this violence was aided and abetted by government officials, or they turned a blind eye to it when it happened by private individuals. And so Congress was concerned that people's rights were being violated, and they needed a way not only to vindicate the constitutional rights that they had, but also to bypass potentially biased state justice systems. So in the Ku Klux Klan Act, Congress created a cause of action in what is now known as 42 U.S.C. Section 1983. That's a section of the United States Code that gives any person the ability to go into court and seek damages and an injunction against anyone who has violated that person's rights under color of state law. So this applies to state and local actors. Local actors also act under color of state law, and the terms are pretty absolute. So anyone whose rights are violated can come on to federal court and assert this cause of action. But the Supreme Court held in 1967 that the 1983, despite the absence of any textual defenses or immunities or exceptions, must have meant to incorporate certain pre-existing immunities that the court perceived to exist at common law. One of those, according to the court, although this is now heavily disputed by legal historians, is this idea of qualified immunity, or what the court then called the defense of good faith and probable cause, which meant that when an officer acted both in good faith, that is, subjectively believing that he was doing a legal thing, and also with probable cause, that is, he thought lawfully, then he could, or that he reasonably believed he was acting lawfully, then he was immune from suit under Section 1983. That has been the law in some form or other ever since 1967, although it's undergone some changes. Now there has been a significant push from both the right and the left of the ideological spectrum, both on the court and outside of it, to reform or abolish that doctrine, which is not grounded in the text of 1983, which actually turns out is unsupported by the history of either 1983 or the common law, and which has the very troubling effect of immunizing serious violations of the Constitution and thus granting officers impunity to do those very same violations again.
So to break it down a bit, essentially the family of George Floyd, right? Section 1983 allows them to go to federal court and basically say Georgia's rights were violated, and they want to be to get some sort of accountability. But qualified immunity stands in the way, even though 1983 allows them to do that. Is that right, Bob?
Yes, that's exactly right. That the question under modern qualified immunity doctrine no longer becomes whether the Constitution was violated. It becomes whether there is a particular case on point that, quote, clearly establishes that the Constitution was violated. And appellate courts, as you said in the intro, get very, very precise in demanding exactly the same scenario. And you get this sort of macabre inquiry into exactly the nature of the violence that was perpetrated in a previous case, as compared to the nature of the violence that was perpetrated in this case, without any inquiry into the core question of just, was this okay in the first place? The thing that I think intuitively most people would think is the question at the heart of the case, did this violate the Constitution, frequently doesn't come up, or at least doesn't come up until you get very, very deep in the analysis and have jumped over some very, very high hurdles.
So Scott mentioned that in 1967 is when the court is essentially starting to talk about this qualified immunity concept. And he also mentioned that there have been several waves of changes. So the modern, current most... it's not exactly most recent manifestation, but sort of the current manifestation of qualified immunity started in 1982 with the case Harlow versus Fitzgerald. Bob, can you talk a little bit about the case and, again, briefly describe what it said about qualified immunity?
Sure. So the court in the 1960s did invent sort of this ahistorical good faith defense. But a lot of what we talk about when we talk about modern qualified immunity and this idea of clearly established law does go back to the court's decision in 1982 in Harlow. And I think it's actually remarkable that the adoption of Section 1983 was obviously motivated by concerns about government violence against people and property. And our modern debates about qualified immunity are animated by concerns about government violence against people and property. And the Harlow case just has nothing at all to do with government violence against people and property. The Harlow case was brought by a former government employee, an official, a civilian staffer in the Nixon administration, who had given some testimony to Congress about a budgetary matter that embarrassed the Nixon administration, and he got fired. And President Nixon openly said, I ordered his firing. I did it. I said, fire that guy. And he sued President Nixon and a couple of high-ranking staff members in the Nixon administration. So the court, in a separate case, held that you can't sue the president for firing you from his administration. He's absolutely immune. And then it, in a separate case, addresses the suit against the staffers. And it's not totally clear from the complaint what exactly the staffers did. The president said he made the firing decision, so they may have written some memos behind the scenes. There's sort of a suggestion that there's this shadowy conspiracy to push him out of his job. And essentially what the Supreme Court says in the course of adopting what becomes the modern qualified immunity doctrine is, look, I don't even know if you can violate the Constitution by doing that. I'm not sure exactly what you think went wrong here with your firing, but it's not immediately clear to us that, writing a memo about whether you should fire a guy can give rise to a constitutional violation, when done by an advisor to the president. And so we're not going to announce that brand new rule here. And even if we did announce that brand new rule, we're not going to hold anybody liable under that brand new rule. And it is, I think, part and parcel, it's a good example, rather, of what's going on behind the scenes and between the lines when the Supreme Court articulates its modern qualified immunity doctrine. I honestly can't think of a modern case where the Supreme Court sat down and said, you know what? This is a really good constitutional claim. This is a constitutional claim that is correct. But we can't find an exact case on point, and so we're going to award qualified immunity for this very, very good constitutional claim. That underlying it is always a deep skepticism on the part of the court about the actual underlying claim. And it seems like qualified immunity is just getting layered on top of that in a way that is leading lower courts to look at perfectly meritorious claims where it seems like no one on the lower court appellate panel really has any desire to say that what the government did was okay, but excluding them on the grounds that the court has said these sweeping things about the importance of qualified immunity, and so we're going to go with what the court has suggested we ought to do, which is dismiss these meritorious claims. And the thing I think is interesting about the cases currently pending before the court is that all of them have these genuinely shocking underlying facts that make it hard to go to bat for the idea that this is just okay, that this should be allowed. And they starkly present the question the modern court has never really had to grapple with, which is, are we supposed to apply qualified immunity to actual egregious violations just because they're factually unique in one way or another?
Yeah, Scott, I'm going to let you react to that and also talk a little bit about sort of to whom qualified immunity applies, because Bob mentioned that, Harlow versus Fitzgerald is involving, high-ranking federal officials and has nothing to do with, like, exercise of excessive force or the debate that's, that we're having today in terms of the killing of George Floyd.
Sure. Let me take those in reverse order, Anya. First, to whom does qualified immunity apply? Virtually every government official. A handful have what's called absolute immunity, which is even stronger than qualified immunity. Judges, legislators, prosecutors, and as Bob mentioned, the president all have absolute immunity, where there's no search for clearly established law. You just say, were you acting as the president? Were you acting as a legislator? Okay, the case is over. But everyone else pretty much gets qualified immunity. That's regardless whether you're a law enforcement officer on the street or a cabinet level official, whether you're a school administrator, whether you're a social services worker. Government officials in general can all claim qualified immunity. So this is a very broad doctrine. And in view of the fact that not only have we been talking about the incredible violence that police can visit upon people, but there are also many ways in our society that other government officials can visit quite a bit of harm, whether it's firing someone from their job, denying them benefits in a discriminatory way, taking somebody's children away. Those are all things that law enforcement officers may not do, but other government officials who can nonetheless claim qualified immunity. As to Bob's point about the evolution of the doctrine, I think it's absolutely right and very important to note the court never sat down and said, this is the qualified immunity we want. They just keep playing this game of telephone where they build on the last thing that they said, and then lower courts take those pronouncements and run with it. And as a result, the court keeps tweaking the doctrine. They keep saying, well, we've got this problem with it, we'll change it. So one of the things they did in Harlow was they abolished the idea that the absence of good faith would defeat qualified immunity. So now a plaintiff can't show that a defendant had a terrible, terrible reason for doing what they were doing. Instead, it's all about that search for prior similar precedent. The court has also considered whether it should change the standard in light of the prevalence of indemnification. This idea that, well, we're really not protecting officers when their employers are going to pay the judgment. Scholars have found that in more than 99% of cases, the officers' employers are actually the ones who pay. So it's not like this is going to bankrupt individual police officers, still the court has not been interested in that evidence. So case by case, they say, oh, well, this claim doesn't look so good to us, qualified immunity. And then they give this sweeping rationale. And it's really gotten out of control in terms of the types of facts we've seen it applied to cases that would shock anybody. And I think probably shock most judges, still get qualified immunity because of this notion that the cops had to have, signed, sealed, and delivered that they could not possibly lawfully do the thing that they did.
So, Bob, in terms of, and you can respond to this as well, but I just want to underline for listeners. So with George Floyd, right, like if his family can actually go to civil court and, there is evidence that the officer acted maliciously, right, that bad faith evidence is not going to matter and qualified immunity is going to protect him anyway?
That's absolutely right. The individual bad faith of a government actor doesn't factor into it at all. And what we've replaced it with is this utterly arbitrary fiction that hinges on the existence of federal appellate case law, even though deep down we all know that nobody's reading the federal appellate case law. And so imagine you have a case that actually is exactly on all fours with what has happened to me. Like there's not going to be qualified immunity because there's an appellate case that says, doing exactly that to Bob McNamara violates the Constitution. If that case was handed down a week before the government violated my rights, the government doesn't get qualified immunity. If that case was handed down a week after the government violated my rights, the person who violated my rights does get qualified immunity. And there's no suggestion that whoever violated my rights, whether it's an administration official, a cop on the beat, a social worker, whoever it was, there's no suggestion that we actually think they're sitting down and the day the 11th Circuit opinions come out, they read every 11th Circuit opinion and digest them and adjust their behavior accordingly. And so what you get is not just a denial of justice, though in a lot of cases it is obviously a denial of justice. You get an arbitrary execution of justice because people do sometimes defeat qualified immunity, but they don't defeat qualified immunity in cases that are more meritorious than the case Scott is litigating. They don't defeat qualified immunity in cases where the behavior is more egregious than in the case with Shanice West. They defeat qualified immunity because there happens to be a case that was decided at the right moment where the facts are close enough, even though none of us think that's actually affecting the subjective behavior of the government officials. So all too often, qualified immunity is a means for the courts to deny justice to individual victims. But when qualified immunity is defeated, on the flip side, it's defeated in ways that make it fundamentally arbitrary, that we're holding government officials accountable who are exactly as morally culpable as government officials who did very similar things and who get off scot-free.
Now, and to build on that point, Bob and Anya, I think to bring it back and make it very concrete to George Floyd, if George Floyd were sued under Section 1983, which, let's not forget, was directed at terroristic white supremacist violence against black people, if George Floyd's family sued under 1983, the cops would come back and say, well, we don't see any cases, any appellate precedent about kneeling on somebody's neck for 9 minutes. And so now the burden's on George Floyd's family to show that some other cases with some other facts put it beyond debate that you can't kneel on somebody's neck. I mean, well, that's a ridiculous question to be asking. Of course you can't do that. Now, the Supreme Court has held out the possibility that in certain very obvious cases, the general rules of the Constitution will be enough to clearly establish the law without a factually specific precedent. But it has said as recently as 2018 that those cases should be rare. And it would be really up to an individual judge or then a 3-judge appellate panel of the Federal Court of Appeals to say whether this was truly obvious enough that qualified immunity is defeated, even though there probably isn't another case that has been decided with a cop kneeling on a motionless person's neck for 9 minutes, even though that's outrageous. Of course, that's a violation. Everyone who has seen that video is shocked and horrified. But the fact that we even have to worry about whether it's been litigated before shows how wrong-headed this whole qualified immunity doctrine is.
So the obviousness exception, then, even though it technically exists, is not really being used very much?
Not very much, no. And the best way that you can see that is by thinking about some of the facts that are now before the court. One would have thought it's obvious you can't get consent to search someone's home and then destroy it. One would have thought it's obvious you can't sick a dog on a man who has surrendered by sitting down with his hands up when you've got him surrounded. Those arguments didn't carry the day. Instead, in both of these cases, lower courts found immunity, and there are more where those come from.
And what's really happened is, Scott's exactly right that the court has never sat down and said, this is the qualified immunity doctrine we want. But what it has done is over the past decade or so, it has increasingly taken up qualified immunity cases, not for plenary review, not for what you see in the newspaper where there's an oral argument and full briefing, but it's just kind of picked cases off the pile for summary reversals where a lower court has denied qualified immunity, and the Supreme Court picks that cert petition off the pile and says, no, here, this person was entitled to qualified immunity. And they don't do anything to change the doctrine. They don't repudiate the idea that there can be obvious violations of the Constitution. But what it's done is send a signal to lower courts. And the signal is, stop denying qualified immunity. We're not changing the doctrine. The doctrine still stands there, and supposedly egregious, outrageous, and obvious violations of the Constitution can result in liability. But apparently we're not really supposed to use that part of the doctrine. And so I think what you see on the part of a lot of appellate judges is a response to the signal that they think they've been getting from the Supreme Court of just, we say qualified immunity is one way. In reality, it's supposed to be the other way. And so we're going to do the other way to you.
Yeah, so I'm thinking about this decision, Hope versus Pelzer, right, with Justice Stevens writing for the majority. And there he actually says it is obviously a violation of the Eighth Amendment right to basically handcuff a prisoner to a hitching pole, right, and let him sit there for 8 hours without giving him any water. While he says it's an obvious violation, he still goes through the analysis of the clearly established law and whether there is precedent on point. So it's kind of, you think, okay, the court is saying this is obvious, but then the analysis does not stop there. So what are lower courts supposed to think?
Well, that's right. And the other piece of hope that I think has left lower courts reluctant to deny qualified immunity is that it happened 18 years ago, and the court has not denied qualified immunity on the merits in any case since then. It reversed one or two cases on sort of technical grounds related to the rules of civil procedure. But since 2002, when it faces the question, is qualified immunity appropriate here based on the application of this clearly established rule and or the obviousness rule, every time they grant immunity. And it's in this summary way that Bob's described, so that they're not actually thinking hard about it. They're just sending this consistent one-way signal to lower courts. More immunity, more immunity, more immunity. And as a result, lower court judges, none of whom likes to be reversed, and all of whom, or many of whom, as Judge Kaczynski has vividly opined, have their sights on higher court appointments one day that depend on their being right on the law a lot. They all say, well, look, I'm risk averse. I'm not going to tangle with the Supreme Court. The Supreme Court keeps saying that all these denials of immunity are wrong, and they keep reversing it summarily. So I'm just going to keep my head down and grant immunity. So there's all the incentive in the world for those judges to do that. And the Kaczynski quote I'm referring to, which I think is quite vivid, is every district court is every district judge is a future appeals court judge. Every appeals court judge is a future associate justice of the Supreme Court. So they're all thinking, how am I not going to get reversed? How am I going to look good? And the Supreme Court says, well, if you deny immunity, if you let the case go forward, we're going to smack you down. So judges don't want that. So they grant.
That's That's a very good point. Bob, so let's imagine that the United States Supreme Court actually says, you know what, maybe it is time to kind of start going a little down a different path and maybe loosening up some of the restrictions that qualified immunity imposes. So let's say they don't want to get rid of it wholesale. What would be the kind of steps in the right direction when it comes to the qualified immunity doctrine?
I mean, why not get rid of it wholesale? But I do think there are intermediate steps, and maybe the clearest step to take is a step where there's an active circuit split in the circuits, is just to affirm that you can defeat qualified immunity by demonstrating that there's a clearly established rule instead of a clearly established factual scenario. And this is something the 11th Circuit just reaffirmed you can do in the 11th Circuit, that you can't do in a number of other circuits, is just say, look, this rule is clearly established enough that any competent officer should know not to break this rule. And so the question is, did he clearly break this rule or not? Which is a much fairer standard and is something that would actually answer a lot of the cases currently pending before the court, where I don't think there's any question that there's a clearly established rule. Like in Shanice West's case, there's a clearly established rule that you need a warrant to conduct a search or a seizure, and it's clearly established that a consent search has to be limited by the scope of the consent you actually got. There's no debate about those two things. There's just a debate about whether anyone ever specifically got consent to go inside and instead destroyed the house with grenades. So if the test is, was the rule clearly established and did this clearly violate the rule? That's an easy question, and it's what the dissenting opinion in Shanice's case said. But the majority opinion in Shanice's case said, no. This doctrine isn't just about putting people on fair notice. We're not saying that a competent officer would have thought that he was obeying the rules. We're just saying that there's no case on point. And I think a good kind of first step back from the precipice that the court has led us to and that it's led the lower courts to is just to say, whoa. You don't have to do the sort of mechanical analysis. You don't have to engage in the elaborate legal fiction that every government official is pouring over the published appellate opinions of their district and only the published appellate opinions of their jurisdiction. It's perfectly okay to say, look, the Supreme Court has established some boundaries. There are some clear rules, and the test for qualified immunity is not whether exactly these facts have occurred before. It's just, does that rule put you on notice that you cannot do this thing? And that's still, I think, an ahistorical immunity, but it's an ahistorical immunity that is much, much narrower than the culture of utter impunity that I think we've seen grow up around what modern qualified immunity has turned into.
And I think, too, that we shouldn't lose sight of Bob's first point. Why not abolish the whole thing? And it's worth mentioning briefly how we've sort of gotten to this point. Despite the Supreme Court's granting immunity over and over and reversing appellate courts doing otherwise for years, nonetheless, there are a number of judges, justices, commentators, advocates who think this is a bad doctrine that has produced bad results. And so you've got this weird disconnect where the Supreme Court keeps applying immunity strictly and vigorously and repeatedly, even as three members currently of the Supreme Court are on record as saying they would like to reconsider it for fairly different reasons. Justice Thomas opined in a concurring opinion a couple of years ago in a case called Ziegler versus Abbasi, which was not primarily about qualified immunity. He went out of his way to point out that qualified immunity is ahistorical. It's really made up by the court out of nowhere. And he's concerned that the doctrine really isn't faithful to not just what Congress would have wanted in 1871, but what the doctrine looked like, what the background legal principles were in 1871. And the court just sort of made it up out of thin air a century later. Meanwhile, in another case, Casella versus Hughes, a dissenting opinion by Justice Sotomayor, joined by Justice Ginsburg, pointed out the terrible consequences of this rule. In that case, a woman was shot when she had been holding a knife, but not advancing on anyone. Apparently, she was acting erratically. Cops were called to the scene. There were several of them there. She was told to drop the knife. She neither dropped the knife nor advanced. And most of the officers didn't do anything. They were content to continue to negotiate with her, see if they could get her to drop the knife. But one hothead decided that he should just go shoot her and did that. And the Supreme Court said, well, even if, nobody was moving and everybody else thought they could keep talking, it wasn't clearly established that this guy couldn't shoot her, so fine. And Justice Sotomayor and Justice Ginsburg said, no, we've really gone too far. This looks like impunity for officers. So both in terms of its consequences and in terms of its origins, qualified immunity has come under attack at the court. It's also come under attack from a number of lower court judges who have pointed out this has led to a mess in application in the lower courts. And Trump appointee Judge Willett of the Fifth Circuit made this point most vigorously. But I think there's no case that better illustrates that than the one that we have asked the Supreme Court to review on behalf of Alexander Baxter. In Mr. Baxter's case, his facts came before the U.S. Court of Appeals for the Sixth Circuit twice. The first panel found that he had defeated qualified immunity. Remember, this is the man who surrendered to police by sitting down with his hands up, because there was a prior case on point in the Sixth Circuit that said you can't stick a dog on a man who has surrendered to police by lying down. The second panel of the Sixth Circuit had a different view. And so the second time around, when the defendants raised qualified immunity again, they drew a different panel and they got a different result. They looked at the second panel looked at exactly the same case and said, well, lying down versus sitting down with your hands up is just not the same. And Baxter doesn't point us to any case about getting a dog sicked on you with your hands up. The man who was lying down didn't have his hands up, so different case. And that just is an archetypal illustration of the absurdity of this doctrine in practice. So now we've got several problems: historical, the practical consistency of it, and other issues of arbitrariness, as Bob has outlined, and also the terrible consequences on the ground in terms of the incentives it gives for police to know and adhere to constitutional limitations. And that's part of the reason why you have the murder of people like George Floyd, because cops have been told by decades of immunity grants that they can do this sort of thing and get away with it.
And I think one thing that is especially useful in sort of the historical criticism of qualified immunity is that it points us to what a saner system might look like. If you look at the law in the 19th century, there were no immunity doctrines like this. Instead, every jurisdiction had a sheriff, and every sheriff had what was called a surety, essentially an insurer who had promised to pay the sheriff's debts if he did his job wrong. And where you actually see case law talking about a sheriff's good faith is usually in litigation about whether the surety has to pay. If the sheriff was acting in good faith, his insurance has to pay up for the mistake he made. And if he was acting in bad faith, his insurance maybe doesn't have to pay. And I think that throws into stark relief the options we have in front of us when we're faced with a violation of the Constitution. You could say, when the Constitution is violated, we want the costs of that constitutional violation to fall entirely on the government official who violated the Constitution. You could say that when the Constitution is violated, we want those costs generally to fall on an insurer, on an entity that can afford to pay the judgment and also has the incentives to maybe set things up on the front end so that there are fewer violations of the Constitution. There are fewer cases like this that need to be brought in the first place. That's the system that actually existed in most of the country in the 19th century when the Ku Klux Klan Act was adopted. But instead, the system we have settled on is that most of the time when the Constitution is violated, the costs of that constitutional violation should fall entirely on the victim, on the one person who didn't break any rules and had no power to prevent the situation. And that strikes me as insane. And in many ways, history is not a useful guide, but this is actually a moment where I think we have a historical experience to learn from that we can easily return to in terms of crafting a system where you have some actual government accountability and a system that brings to bear some measure of justice with claims like this.
And so how would that system kind of protect an officer who is behaving in good faith, trying to do the best he can, but it just happens that, he ends up hurting an individual without meaning to? How would that system address that particular issue?
Well, I think there are two things you have to understand when talking about that officer. One is that any claim against an officer is going to be grounded in reasonableness. Like the underlying substantive constitutional standard already asks if the government official acted reasonably in the context. And so I think that the substantive standard eats a lot of concerns people have. What if someone was acting perfectly reasonably and just made a mistake, made a slight error of judgment in a split-second decision? Well, that seems like a question about reasonableness, right? That seems like the underlying question of whether this violated the Constitution in the first place. Once we conclude that it did violate the Constitution, that it was unreasonable given all the circumstances, the question becomes, what ought we to do? And it seems perfectly reasonable, to coin a phrase, it seems perfectly reasonable to me to say that in this situation, we want the damages for that mistake, that error in judgment, to be borne in the first instance by an entity that has some ability to affect how often mistakes like this happen. And I think the George Floyd case, tragic as it is, gives us an example of the problems with the culture of impunity. I think a third-party insurer looking at a police force would be likely to say, hey, this guy who's had over a dozen disciplinary complaints perhaps is not going to be the best decision maker. Perhaps putting him out on the street armed is opening us up to mistakes happening that we don't want to make. And I think judgments in constitutional cases are a useful tool, a useful signal saying, hey, you need to put in practices on the front end, making sure that your employees, again, whether they're the police, whether they're social workers, whether they're whoever else works for the government and can take away your stuff, your kids, or your rights, that they are in a position to make the best decisions, that you are putting the best people out there, that you are training them properly, that you're giving them the resources they need to succeed, because if they don't succeed, there are going to be consequences. The system we have right now says if they don't succeed, there are going to be consequences, but those consequences will fall solely on their victims. And that seems entirely morally backwards to me.
Yeah, so it makes sense, kind of setting up the structural system of incentives, essentially, that would reduce constitutional violations as a whole going forward. And to learn more about doctrines that involve constitutional accountability, and qualified immunity being just one of them, take federal courts class. And if you're not planning on doing that, then go to our website and check out our page on Project on Immunity and Accountability, where we discuss not only qualified immunity, but also other doctrines that make it very, very difficult to sue government officials of all levels, federal, state, local, municipalities, and how difficult it is to actually get them to hold them accountable for violations of constitutional rights. Thank you so much, guys, for being here, and I hope we get to talk about this again soon, and hopefully we'll have some really good news to share.